What can you say? It's good to be a member of Congress. Viva Frei, Montreal litigator turned YouTuber, and for those of you who have been around the channel long enough, you know that I have done extensive vlogging on the Nicholas Sandmann defamation lawsuit. Now, some of you actually might not know this, but there are two sets of parallel proceedings. You have Nicholas Sandmann versus the Washington Post, CNN, and other major news outlets, and you have the Covington Catholic kids against a variety of defendants, including Senator Elizabeth Warren and Deborah Haaland. Nicholas Sandmann is being represented by L. Lynn Wood, and the Covington Catholic kids, who are anonymous plaintiffs, are being represented by Robert Barnes. Nicholas Sandmann is suing major outlets for $250 million, whereas the Covington Catholic kids are suing a bunch of defendants for anywhere between $15,000 and $35,000. Give or take, they're suing for much, much less than Nicholas Sandmann is suing the major outlets. And in December 2019, the Covington Catholic kids lawsuit took a bit of a hit, at the least as relates to Elizabeth Warren and Deborah Haaland, in that the lawsuit was sent to the federal courts on a jurisdictional issue and then dismissed on a sovereign immunity issue. I did a vlog on it at the time where I explained the differences between the Nicholas Sandmann lawsuit and the Covington Catholic kids lawsuit, the issue of the jurisdiction, the sovereign immunity, and the judgment dismissing the claim. If you haven't seen that video, go give it a watch. I'm going to link it right here. It'll give you a better understanding of what's happening in this vlog. Robert Barnes, representing the Covington Catholic kids, took that decision to appeal, and in June 2020, he made his oral arguments before the Sixth Circuit, and if you haven't seen that or actually heard it, I put up a video at the time with all of his oral arguments. It's fascinating to listen to. Give it a listen. It's 42 minutes long, but it's worth it. Link right here. Well, the fruits of Barnes's labor is in, because on September 3rd, the Sixth Circuit Court of Appeal rendered a judgment, and they dismissed the claim, reaffirming the original judgment, dismissing the claim on the basis of sovereign immunity. Or, as Robert Barnes eloquently put it on Twitter, Sixth Circuit holds laws passed by Congress give members a license to libel private citizens far beyond the speech and debate clause, even for social media lies about private citizens and minors, giving Senator Warren immunity for her libels of Covington boys.
To the Supreme Court.
Well, Robert, from the tips of your fingers to the ears of the gods of the Supreme Court, but let's first read the judgment from the Sixth Circuit Court of Appeal. We first start with the factual background, which I'll go over quickly because I take for granted most of you know it already. Plaintiffs are 10 unnamed minors who, at the time of the events in question, attended Covington Catholic High School, a private school in Park Hills, Kentucky. According to plaintiff's complaint, on January 18, 2019, plaintiffs joined a larger group of classmates on a trip to Washington, D.C. to attend the anti-abortion March for Life. You know what? Skip it. Everybody knows the facts. They ran a story that proved to be somewhat inaccurate, to say the least, and politicians like Elizabeth Warren and Deborah Haaland started tweeting out things which were inaccurate, to say the least. The public statements regarding the video that are relevant on appeal are those sent by Representative Deborah Haaland and Senator Elizabeth Warren. On January 19, 2019, Representative Haaland sent a tweet from her official congressional Twitter account that read, quote, "This veteran, Nathan Phillips, put his life on the line for our country. The students' display of blatant hate, disrespect, and intolerance is a signal of how common decency has decayed under this administration. Heartbreaking," end quote. She later sent a tweet from her campaign Twitter account that linked to a Huffington Post article about the incident that included a video interview with Phillips following his interaction with the students, in which he stated that they were chanting, quote, "Build that wall," end quote. Her tweet stated, quote, "A Native American Vietnam War veteran was being harassed and mocked by a group of MAGA hat-wearing teens," end quote. On January 19, Senator Elizabeth Warren sent a tweet from her official Senate Twitter account that stated, quote, "Omaha elder and Vietnam War veteran Nathan Phillips endured hateful taunts with dignity and strength, then urged us all to do better. Listen to his words," end quote. So that is the factual background. Those are the allegedly defamatory tweets. Now let's do a little bit of the procedural background. On August 28, 2019, Senator Warren removed the case to federal district court, citing the Federal Officer Removal Statute, 28 U.S.C. Section 1442A1, as the basis for removal. Then, on September 4, 2019, Senator Warren filed a motion to dismiss for lack of jurisdiction and for failure to state a claim on which relief could be granted. Representative Haaland subsequently filed her own motions to dismiss. On September 26, 2019, plaintiffs filed a motion to remand to state court. The district court issued an opinion and order in which it found that removal was proper under the Federal Officer Removal Statute, denied plaintiffs' motion to remand, and granted Senator Warren's and Representative Haaland's motions to dismiss. It concluded that regardless of whether one agrees with Warren's and Haaland's communications, they were, quote, "intended to convey the politicians' views on matters of public interest to their constituents," end quote. Therefore, quote, "the statements were made within the scope of defendants' employment as elected representatives," end quote, "and they were entitled to the benefit of sovereign immunity pursuant to 28 U.S.C. Section 2679B1. Now, we're going to get into it a little bit later, the issue of sovereign immunity, but basically, for the time being, sovereign immunity means that you can only sue the state when the state says that you can sue it.
It's good to be the king.
But before we get into the sovereign immunity argument, we have to see how the court sidesteps the entire argument based on the speech and debate clause. Plaintiffs mistakenly framed defendants' claim for immunity from libel suits as one premised on the speech and debate clause, which states, quote, "For any speech or debate in either House, senators, or representatives shall not be questioned in any other place." United States Constitution, Article 1, Section 6, Clause 1. This clause provides Congress members a limited form of legislative immunity from suit. However, the clause only protects speech made in the context of, quote, legislative activities, end quote, and the, quote, legislative process, end quote. In the present case, plaintiffs contend that, quote, responding to questions about their job as Congress members has been the only category of claims found immune from tortious libels outside of legislative duties or the legislative chamber, end quote. And so defendants' tweets are not protected by the speech and debate clause. Whatever the merits of plaintiffs' argument, neither Senator Warren nor Representative Holland have cited the speech and debate clause in either their motions to dismiss below or in their filings before this court to demonstrate the lack of federal subject matter jurisdiction over this action. Consequently, plaintiffs' arguments on this point are irrelevant to the issue presented in this case. Now, I will be discussing this with Robert Barnes during our next live stream on the subject, but I'm not entirely certain that this is an accurate way of dismissing Robert Barnes' argument. My understanding is that the argument is that the law does not extend the immunity to Congress members beyond that which was provided for in the Constitution in the first place. Instead, defendants rely on the Federal Tort Claims Act, the FTCA, 28 U.S.C. sections 1346 and 2671 and following, as amended by the Westfall Act, 28 U.S.C. sections 2679b1, to undergird their immunity claim. Quote, "The United States as sovereign is immune from suit save as it consents to be sued, and the terms of its consent to be sued in any court define that court's jurisdiction to entertain the suit." United States versus Sherwood. The FTCA waives the United States sovereign immunity for certain torts committed by federal employees while acting in the scope of their employment. In general, the FTCA provides federal district courts exclusive jurisdiction over claims against the United States for, quote, injury or loss of property or personal injury or death caused by the negligent or wrongful act or omission, end quote, by federal employees acting within the scope of their employment. It does not, however, waive sovereign immunity for claims, quote, arising out of libel and slander. End quote. So even more simply put, the federal government says through the FTCA, you can sue us for certain things done in the context of your employment when we say you can sue us for that, and we did not say that you could sue us for libel or slander. If it happens, too bad, so sad, it's
Good debate, King.
Prior to 1988, litigants could sue federal tortfeasors in their individual capacity subject to specific exceptions created by Congress to protect certain classes of employees from personal liability. In 1988, Congress abandoned this piecemeal approach and passed broad legislation to extend the benefit of sovereign immunity to all federal employees. This law, the Federal Employees Liability Reform and Tort Compensation Act, i.e. the Westfall Act, amended the FTCA to provide that, quote, "The remedy against the United States provided in the FTCA is exclusive of any other civil action or proceeding for money damages by reason of the same subject matter against the employee whose act or omission gave rise to the claim or against the estate of such employee," end quote. The Westfall Act was named after the decision of that name, Westfall versus Irwin, which created the problem that the Westfall Act sought to remedy. Westfall versus Irwin held that government employees could be liable in tort for non-discretionary actions within the scope of their employment. That case, quote, "eroded the common law tort immunity previously available to federal employees," end quote. The Westfall Act amended the Federal Tort Claims Act to require that the United States be substituted as the defendant in any tort suit brought against a government employee acting within the scope of her employment. And based on that framing of the debate, you know exactly where the court is going to go with its decision. To prevail, defendants must demonstrate that members of Congress are protected by the Westfall Act. They must first show that Congress members are, quote, employees of the government. Plaintiffs contend that, quote, there is zero evidence that the Westfall Act was about Congress members at all, end quote. Although we have not yet considered this issue, the First Circuit has squarely held that members of Congress are government employees for the purposes of the FTCA. Moreover, while contemporary legislative history from the passage of the Westfall Act does not directly address this question, as the First Circuit queried, quote, "Why would congressmen vote to exclude themselves from a universal grant of immunity given to all others, to all employees below them, to all officers up to the president above them," end quote. We agree that it is highly unlikely that Congress would exclude itself, sub silencio, from such a broad grant of immunity. This conclusion, coupled with the unambiguous text of the statute, makes clear that members of Congress, representatives and senators alike, enjoy the benefits of the FTCA as amended by the Westfall Act. Now, the court's argument here is, why would Congress members give immunity to all federal employees if they didn't also intend to give immunity to themselves through the Westfall Act? And you know what? This lighting is a little too sharp. I'm going to roll down the windows and close the sunroof.
I'm not worried about it, but I don't want
Turn off the radio. Fix the office. Roll up these. There we go. That's a little better. Okay, we're good. Why would Congress members grant broad immunity to all federal employees but exclude themselves? It's an interesting argument. If you are going to bestow benefits on other people, why not bestow them on yourself? Because after all...
It's good to be the king.
And the court concludes that Congress members did indeed intend to grant themselves immunity. Now the only question left to determine is whether or not they were acting in the context of their employment. Now, from what I understand of Barnes's argument is that the Westfall Act did not intend to expand immunity. It only intended to confirm existing immunities. And the only existing immunities that existed for Congress members related to the speech and debate clause. But the court says no, it's a no-go. You shall not pass. Now let's see what they say about whether or not Congress members were acting in the context of their employment as Congress members. What do you think they're going to say? We turn now to the central question presented by this appeal, whether Senator Warren and Representative Holland were acting within the, quote, scope of their office or employment when they sent the allegedly defamatory tweets. If they were, then they are entitled to the protection of the Westfall Act. In the present case, the forum state is Kentucky, and the conduct, i.e. the allegedly defamatory tweets, occurred in Kentucky because plaintiffs live in Kentucky and the tweets were accessible in that state. Kentucky law focuses on an employee's motive to determine whether she was acting within the scope of her employment when committing intentional torts, including libel. Neither Kentucky courts nor this court have decided whether statements such as those at issue, unsolicited comments by elected officials on an event of widespread public interest, are within the, quote, scope of employment, end quote, of members of Congress. However, out-of-circuit precedent involving situations closely aligned to the facts of this case strongly supports finding that these tweets were within the scope of defendants' employment as officers of the United States.
Color me shocked.
In the present case, the articles shared by Senator Warren and Representative Holland discussed an interview in which Nathan Phillips recollected hearing chants of, quote, build that wall, end quote, emanating from the crowd of students. This reasonably relates the political subtext of the incident to President Trump's well-known campaign promise to build a border wall with Mexico. Far from being gratuitous, these tweets fit within the, quote, wide range of legitimate errands performed for constituents, end quote, which includes, quote, preparing so-called newsletters to constituents, news releases, and speeches delivered outside the Congress, end quote. There is no meaningful difference between tweets and the other kinds of public communications between an elected official and their constituents that have been held to be within the scope of employment under the Westfall Act. And that is the decision of the Court of Appeals. The Westfall Act intended to extend the immunity of Congress members beyond the speech and debate clause. They were acting within the context of their employment, therefore they are covered by the immunity of the sovereign immunity, therefore no claim against them.
Too bad. So sad.
Go home, you're done. Or, as Barnes has vowed,
To the Supreme Court.
to be continued, to be discussed. If you like my videos, if you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. If you want to support my channel, all of the support links are in the pinned comment. We've got PayPal, Subscribestar, YouTube membership, Patreon. We've got merch. Politics ruins everything. But above all else, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah.